Hi, this is Alan from Alpus Group, and I'm going to talk to you today about arbitration and dispute resolution and the background to why you should never get in this situation. I have only ever been involved in one litigation in my career, and this was owing to a big mistake by a client who signed up to a construction contract which had been prepared by the contractor. So I'll just give you a little bit of background. This is a massive project in Baku in Azerbaijan, value $1.5 billion, so probably more than that. But anyway, that's not so important. But I want to explain to you why you should never do what this client did. At the time that I was involved in this project, which was between 2010 and 2015, and we took the project from essentially what was an area of Baku port. You'll see here the wharf on the left-hand side, and you'll see there's a cofferdam which goes around, which encloses an area of sea, which is subsequently reclaimed in the other subsequent photographs I show you here. You can see the dewatering is going on, and you can see the start of the build-up of the new foundation layer for the what will be the hotel side. Originally, the client was in discussion with another contractor called Codest, who were going to carry out this work and for the whole development. And unbeknown to us, I was working for the engineer, basically the project manager for the job. The client was at the same time conducting negotiations with another contractor called Strabag, who also wanted to carry out the work. And I can remember distinctly one day being called to a meeting with the client, and the contractor, the new contractor, was present. So the client had decided to award this contract to Strabag, despite the fact they were in a memorandum of understanding with the previous contractor, Codest, and the contractor at the meeting was beaming. All their legal people were beaming from ear to ear, and I can remember it distinctly because I thought, I wonder what has gone on here. And when we eventually got to see the contract that the client had signed some weeks later, we realized that the client had let themselves in for big problems. This is the work going on, further filling of the site, reclamation of the site. And the reason I say that is because the new contractor was terminated from the project owing to lack of performance. And what they did was they raised a claim in the International Court of Arbitration that the client had terminated their contract for convenience. So in the contract that Strabag had drafted, they in fact included a clause that allowed them to claim in the event of such an occurrence, i.e. the client terminating for convenience. So the client didn't terminate for convenience, they terminated because of lack of performance on the part of the contractor. But the point I'm making is that you should always seek advice before you enter into a contract, because the implications can be quite dramatic. And you see the work going on here for the reclamation of the site, ready to construct the podium for the hotel. And here you see the podium rising for Crescent Place, part of the development. And this is the Crescent Development Hotel, Crescent Hotel part of the development. And this is the whole of the construction rising. The point I'm making is that the claim that was put in by this contractor who was terminated was massive. It was $250 million, and it was fought at the International Court of Arbitration. The client incurred massive costs, as did Strabag, and neither party actually won from this. They both lost out because they both incurred massive cost. But the point I'm making is that this mistake of going into a contract which hadn't been properly reviewed and corrected, i.e. the client signed up to a contract prepared by the contractor, was a massive mistake and subsequently led to other problems. So what my advice is to always get professional advice before you enter into a contract, and ideally you want to be dealing with a company that gives you an ethical approach and full visibility of what you're doing. So don't fall into the same trap of falling for a contractor's spin on a particular contract because it's convenient to get into an arrangement with them. You need to seek professional advice before you enter into any contracts, and so you will avoid getting into arbitration and litigation situations. As I say, I've never been involved in such a situation until that project, and it was a real lesson for me that the best way to resolve problems is by reasonable discussion between the parties, negotiation and action to resolve the problems that are holding the project up. It's certainly not by going to arbitration when in fact the job takes on a life of its own because legal teams and experts get involved, and all of a sudden the project takes on a new life, but it's actually costing a lot of money for the client. So when you consider going into any sort of contract with a contractor or a designer, then make sure that you have the right advice and that you are entering into a contract which does not include any surprise clauses like this one did from the legal team of the contractor. There are obviously some very astute people working for contracting organisations, and you as a client need to ensure that you protect your own interests. That's all for now. Cheers.